Hello everyone. First of all, thank you for your time. My name is Tanya and the case I'll be talking to you about today is Statham and Anor and the Federal Commissioner of Taxation. Now in this presentation I will outline the facts of the case. I will also talk about the legal principles established by this case and whether they're still applicable today, the year 2020, and then I will talk about the impact the case has on advice given by tax practitioners to their clients. Let's get to it. So in the case of Statham and Anor and the Federal Commissioner of Taxation, there is a man called Charles Adamant, and in the year 1970 he purchased a rather large farm with the intention to bring his family up in a rural area and to engage in some distillery farming. In 1976, he sold some of this property to his brother-in-law and his sister's company, Bickerton Holdings Pty Ltd. Later on that same year, 1976, the two parties formed a partnership for the purpose of cattle farming. Now, the cattle farming didn't pan out too well due to a couple of reasons. The decline in health, Charles Adamant's health. There was also a really bad cattle market at the time. So then in 1979, the co-owners decided to subdivide and sell the land. Now, the subdividing of the property was done by the local council, with the co-owners providing a bond to the council by way of bank guarantee. Now, all the subdividing work was done by the council. The establishment of roads, sewage and electrical works were all done by the council. Unfortunately, in the year 1980, Mr. Adamant's health declined drastically and sadly he passed away. The subdivided lots were then marketed and sold by local estate agents between the years of 1980 and 1986. Now, going forward in this presentation, when I say deceased, I'm referring to Mr. Adamant, and when I say taxpayers, I'm referring to the trustees of Mr. Adamant's estate, who are also the applicants of this case to the federal court. Now, what happened next was the Federal Commissioner of Taxation assessed the net proceeds of the sale of the subdivided lots as assessable income to the taxpayers as the trustees of the estate under Section 25(1) or either Section 26(a). The Commissioner contended that even though the property was originally purchased for domestic purposes, it had been committed to the business of land subdivision and development, or alternatively the deceased had been engaged in profit-making undertaking or a scheme in respect of the land. The taxpayers argued that the land was not committed to the business of subdividing land or development. Neither was the deceased ever involved in any profit-making undertaking or a scheme. Rather, it was argued that the land was merely being realized in the most advantageous way available, which was by the subdividing and sale of the land. And accordingly, the net proceeds which arose from the sale of the subdivided lots should not be accessible to the taxpayers. The main question or issue the courts had to solve was, did the net proceeds from the sale of the subdivided blocks constitute accessible income? To be accessible income or not to be accessible income? That is the question. The full federal court panel, made up of Woodward, Lockhart, and Hartigan JJ, held in favor of the applicants, the taxpayers, that the net proceeds received from the sale of the subdivided lots did not constitute accessible income under either Section 25(1) or 26A. Per Woodward, Lockhart, and Hartigan JJ, the mere realization of an asset at a profit does not necessarily render the profit taxable. The profit must arise from the carrying on of a business or a profit-making undertaking or a scheme. The mere magnitude of the realization activities does not convert into a business undertaking or a scheme. So basically, the legal principles here is that profit arising from the realization of an asset does not necessarily mean the profit is taxable, and also the scale of the activities does not always mean that there is a business going on or profit-making undertaking or a scheme. Now, the legal principles are still applicable in some form today, 2020. I say 2020 because, those tax rules, they're always changing. So they might change in the next, or a year. Now, Mr. Adaman bought the land in the year 1970, which was about a decade and a half prior to the capital gains tax regime coming into effect on the 20th of September 1985. The subdividing of the land also occurred in 1979, which was also prior to the CGT implementation date. Today, when you subdivide a block of land, you create a new asset and you have to register it and get a new title for that block of land. The subdividing of the land does not create a CGT event, but if you do sell the land and a profit is gained, then it could be subject to either CGT or it'll be assessed as ordinary income if intention in subdividing the land was for profit making, or if profit was made in the course of carrying on a business or a business operation or a commercial transaction. Sound familiar? The case of Statham and Anor and the Federal Commission of Taxation has contributed to the way profits from the subdividing and sale of land is classified for tax reasons these days. Tax practitioners have to take into account several things when they're advising their clients when it comes to the sale and subdivision of land. They have to take into account the dates and the years that the land was acquired, the date the land was subdivided and sold, and they also have to take into account the intention of the subdividing of the land, and finally they also have to take into account whether the land was subdivided and sold in carrying on a business or for business operations or in a commercial transaction. Now that about brings me to the end of my presentation. I'd like to thank you all once again for your time. Thank you for listening and happy studying. out of here.